been 2 weeks since the last big motions hearing in the case against the 6 officers accused in the death of Freddie Gray. And since then, both sides have been preparing for the first trial, scheduled for October 13th.
And according to court records, we now know which officer will be tried on that date. Tonight, what that tells us about the state's case and what other motions have been filed since mid-September. The state is looking to try Officer William Porter in October. He would be the first of the 6 defendants to stand trial. Porter is indicted on manslaughter, second-degree assault, misconduct, and reckless endangerment in the death of Freddie Gray. While much of the evidence the state plans to put on is still not public, trying Porter first is still very telling to attorneys following the case.
Well, you're going to put your best cases on first. I mean, it's very similar to a sports analogy of the Orioles manager deciding to go with his ace first. He wants to get off to a good start.
Doug Colbert is a professor at the University of Maryland Law School. He says if Porter is first, it likely means it is the state's best shot at a conviction. And like in a baseball playoff series, starting with a win could set the team up nicely for the other games. Conversely, though, a failure to convict can very well do the same for the other side.
If you're the lawyer for the 3rd or 4th defendants, you're going to be looking very closely to see what the outcome was and what type of evidence the state produced.
But in some of the later cases, the charges on which the defendants will stand trial is not exactly settled yet. Other recent filings include a motion to dismiss the reckless endangerment charge for Lieutenant Brian Rice and officers Miller and Nero. The issue surrounds the inaction of not seatbelting Freddie Gray into the back of the police van. The defense is arguing the 3 officers would not only have to know that not belting Gray would cause his death, but also be aware of the rule to use belts in the vans. In May, ABC2 News first reported that the police order to belt suspects in the back of police vans was approved and sent out to officers just a mere 2 days before the Freddie Gray arrest.
A lot of this comes down to the reasonableness of that situation, and if they didn't know and it was unreasonable, how can they be found guilty of that crime?
Jeremy Eldridge is a former Baltimore assistant state's attorney and says the defense attorneys can make an interesting argument to dismiss the reckless endangerment charges.
When was the duty created, and were they aware of that duty even being created? And if they weren't, then how in God's name can they be liable for something they didn't know about?
Now, meanwhile, Judge Barry Williams had a scheduling conference today, basically a progress report for both sides to check in with him to see if the case is on track to start October 13th. In addition to the charges of reckless endangerment issues, both sides have to come to terms on disagreements about discovery issues, DNA evidence, and expert witnesses. Some attorneys tell us it is possible the October 13th date could be pushed back while these issues are hashed out.